going to move on to Sam Cuthbert and Klara Dvorakova. Sam, you're going to go second, I think, and I think Klara is going to speak first. Is that right?
That's right. Although Klara sadly can't be with us, but she has pre-recorded, as you can see on the screen, her presentation. So she'll.
Okay, well, let me just tell you a little bit about Klara before we start. So Klara is a leading travel law specialist in the Czech Republic. She's successfully represented clients of bankrupted tour operators in disputes on paying insurance claims. She is the author of the first Czech complex legal book on travel law and is multilingual. Sam Cuthbert joined us at Outer Temple last year. He's a published author in the sports integrity section of the Lloyd's Sport Yearbook, and sport as well as travel is a real keen interest of his. He's recently acted for Motorsport UK in a multi-day inquest. And as you said, Klara's going to speak first.
Do you know that you have fantastic climbing spots in the UK? I will show you because I tried some of them. On the left side, you can see me climbing in Weymouth, Dorset. And on the right side, you can see me trying to make it up all the way to Ben Nevis. I could definitely spend 30 minutes talking about some of your decent climbing locations. Many of them are located only a short drive from Manchester or Leeds. But I will not speak about my climbing achievements today. Actually, I am no Adam Ondra, the world famous Czech climber, but I will not go too far from climbing lines. I will present about climbing and mountaineering case law. The ultimate reason of my presentation is to introduce you to the brand new UIAA database of climbing and mountaineering case law. And here comes the question, why me? Why me, Klara Dvorakova, Czech attorney from Prague, from Holubová Advokáti, who is generally specialized in professional liability, personal injury, and travel law advisory? Why it's me speaking about climbing and mountaineering case law database? Well, it is easy. It is because of my hobby activity, and it is because my hobby activity is the involvement in UIAA as the president of the LAC, Legal Affairs Commission of UIAA. Do you know what UIAA means? If you don't, then be aware that UIAA is the abbreviation for International Mountaineering and Climbing Federation. International Mountaineering and Climbing Federation is an association under Swiss law, which members are mainly alpine clubs from across the world. And this organization is some kind of a voice of climbing and mountaineering community. You might have seen the UIAA logo, which you can see on the slide, because it is very often depicted as a safety label on mountaineering equipment. UIAA has many commissions, such as Training Commission, Safety Commission, Anti-Doping Commission, Medical Commission, and it also has a Legal Affairs Commission, which I'm currently presiding. The purpose of LAC is to provide legal assistance to other UIAA bodies when they are working on different projects. LAC is formed of lawyers from national mountaineering associations. Currently, LAC has 11 members. For example, from US, France, Spain, Northern Macedonia, Iran, South Africa, New Zealand or Switzerland, and of course from the Czech Republic. We are slowly covering all continents, which is making me very happy. But we do not have a member from UK, which is also a subtle reason for making this presentation. LAC members have always been collecting judgments, and it has been our dream to create a database of them. A year ago, we actually started working on it. We created a single template, which we started filling with different judgments. The template contains categories of information such as country of accident, country of judgment, mountaineering activity involved, summary of reasoning, damages awarded or not awarded, summary of facts, and it also contains category of information called LAC comments. LAC comments are there to emphasize the important aspects of the judgment, and it is there mainly to look at the case from the point of view of climbers and climbing clubs, climbing community. We plan that in the future there will not only be LAC comments, but there will be also comments from other UIA commissions. So, for example, also the training commission will look at the case, and they will add information which is important from it, for example, from the prevention perspective, from the training perspective. The template is in English, but it also contains a link to the original judgment. When we created the template and started filling the first judgments in it, then we also moved to the technical solution. And the technical solution is already existing and it's beta version. I will show it to you right now. This, what you can see on the slide, this is the front end of the database. You can see that it's a search engine which already contains lots of information, different search engine categories, and it's already existing. When you go to the blue link, then you can try it. I am suggesting you to do it, but as I said, it's only a beta version at the moment. So when you try it, you will only find 3 judgments. In a moment, I will give you a taste of what kind of cases you can find in the database. But before I do that, I want to drive your attention to 2 documents, which to me are very important for lawyers who are dealing with cases involving climbing and mountaineering. The first document is Tyrol Declaration. Tyrol Declaration on best practice in mountain sports, which was passed by Conference on the Future of Mountain Sports in Innsbruck in 2002, is important for lawyers because it contains a very exhaustive list of climbing games / climbing activities, and it also defines them. It also describes values and maxims to provide guidance on best practice in mountain sports. And it contains principles and standards of conduct. So, for example, to give you an idea, in Article 5, you will find responsibilities of mountain guides and other leaders. And for example, in point number 2, you will find that there is a rule that the selected route should relate to the skill and experience of the client or the group in order to ensure it is an enjoyable experience. I think that as a lawyer who is preparing claim arising from climbing and mountaineering, you need sentences like that, don't you? The second document I want to show you is Memento. Memento, or also called Handbook for Alpine Climbs, for Alpine Clubs, is the methodology book. It is the essential knowledge for hiking, climbing, and mountaineering instructors. Many climbing cases are about following climbing methodology. And this book is the up-to-date methodology accepted by Alpine clubs. Even if you are not a climber, it is good to have an idea what the rules are about so that you can understand the case. And as lawyers dealing with climbing personal injury cases, I really suggest that you have this book in your library. So enough of theory, enough of books. Now let's go for the real cases. I will now present 5 cases which are all already inserted in the database or will be visible to you very soon, so that you can have an idea what is in there. The first case is the Swiss case, and it is about a mountain guide who took a group of clients on a ski touring trip. Despite the avalanche risk, he chose a dangerous route with a steep slope. In order to assess the avalanche risk, he performed a simple test of the snow with the stick. He didn't take any other precautions. As his clients were descending one by one, the last client triggered an avalanche and died in it. The criminal proceedings were started against the guide, and eventually he was found guilty of negligent homicide. Why do you think is this case interesting? Well, I found that, or we found as LAC, found that there were two interesting aspects in assessing the duty of care in this case. The court found out first that the guide breached his duty of care because he chose dangerous route when a safe alternative was available. And second, he breached the duty of care because he didn't take other precautions available. The court in this case specifically highlighted the importance of so-called official avalanche bulletins. In Switzerland, there is an official avalanche bulletin, which according to my LAC colleague who brought the case in, is some kind of a golden standard. Everyone is considering official avalanche bulletin when going to the mountains in Switzerland. And this guy didn't do it. Nevertheless, the court is saying the mere fact of not consulting the avalanche bulletin does not necessarily lead to a breach of duty of care if there is foreseeable avalanche risk, if the risk is known in general. But my advice would be, if you're going to the mountains in Switzerland in winter, always consult the official avalanche bulletin. The court in this case concluded that the guide's decision to take the risky route without adequate precautions exceeded the permissible limit of risk and constituted culpable negligence. The specificity of this case from the Swiss point of view is that the guide was also ordered to compensate damages in the criminal judgment, which, as my Swiss colleague said, is not typical. If you are interested in the details of the case, you can already read the summary or the original judgment because it is in the database. And here you go. You can have a look how the beginning of the summary of the case in the database looks like. And we can follow to the next case, which is a Czech case. Czech rappelling case. The Czech case is about a climber who was accused of causing serious bodily harm to another climber during a rappelling descent. He was an experienced climber, but he failed to secure the free end of the rope properly. And he also didn't check the remaining length of the rope while lowering his friend. As a result, his climbing partner fell and sustained severe injuries. Why is this case important? It is because the court determined that the belaying climber was negligent when he deviated from the recognized rappelling methodology set by the Czech Mountaineering Association. The court highlighted the importance of climbing methodology in establishing the duty of care and the necessary degree of caution in sports. So to say, this case about the importance of climbing methodology. And the court even went further and it recognized the methodology as the regulatory tool to minimize accidents in the risky sport. The judgment also reinforces the importance of adopting proper habits and practices to minimize risks in climbing. On another note, a majority of climbing clubs' methodologies are now based on Memento, which is, I wanted to show you this 400 pages book at the beginning of my presentation. It is a nice judgment, which also deals with different reasons to waive criminal liability, and you can read it and its detailed summary in the database. The Czech case about negligence belaying is a criminal one, as was the Swiss case. But negligent belaying is a very popular cause of climbing accident, and in many countries you will find similar cases in the civil proceedings. We have one Spanish case waiting to be reviewed by LAC, and so you can be looking forward to the civil belaying case summary very soon. Now we are moving across the ocean to a US civil case. It is a case Blythe versus Rainier Mountaineering, in which Mr. Blythe, a claimant, participated in a mountain climbing seminar organized by Rainier Mountaineering. He enrolled in the seminar as both a student and a physician responsible for the medical portion of the program. He had no climbing experience, and during the rescue practice, while being lowered into a crevasse, he suffered a serious leg injury. The issue at hand was whether a release of liability, which Mr. Blythe signed prior to the seminar, preventing him from pursuing a lawsuit. The court relied on the precedent, which was set by the case of Hewitt versus Miller, and this precedent established that contracts against liability for negligence are generally valid unless there is a public interest involved or the negligent act falls greatly below the established legal standard for protecting others against unreasonable risk of harm. This being said, the court and also the appellate court concluded that the mountaineering does not involve public interest, and Blythe had not claimed that the alleged negligence fell greatly below the legal standard. That's why the court upheld the validity of release, resulting in no damages awarded to Blythe. And this case is notable as the first lawsuit in the United States involving claims from mountaineering accident related to a commercial guide service and the outfitter. To me, this case is very interesting, but it's a little bit from different world because, for example, in the Czech Republic, this kind of release would never be found valid because in the Czech Republic, you cannot waive your rights in relation to personal injury in advance. A very interesting case to me is the case which was brought to LAC by our colleague from South Africa. And it is a civil case, ZA versus Smith and another. This case is interesting to me because it highlights the liability of landowners, particularly in commercially operated areas, such as nature reserves. And it highlights that these owners should take positive measures to prevent damages. Actually, I'm wondering whether when he's going to have a similar, whether Sam, who is going to speak after me, whether he's going to have a similar case related to skiing and the owner of the skiing resort. In this case, a group of hikers came hiking to the park, and one of them slipped on the ice-covered snow and then slid over the edge and died. The secondary victims filed a claim for compensation against the owner of the farm. The claim was based on the alleged omission of the defendant who failed to warn the deceased, a paying visitor to the nature reserve, of the existing risks. According to South African colleague, the case is very important because it considers the elements of wrongfulness and negligence under common law. The court stated that an omission is wrongful if the defendant is under a legal duty to act positively to prevent harm to the plaintiff. The test for such duty is one of reasonableness. The court also discussed the test for negligence, which requires foreseeability of harm, reasonable steps to prevent harm, and the failure to take such steps. In this specific case, expert evidence from members of the Mountain Club of South Africa described the prevailing conditions as objectively dangerous, with a layer of unfrozen snow concealing a slippery layer of frozen ice. And the court found that the defendant's omission to warn the deceased of these dangerous conditions was wrongful and negligent. The next case, which you will see in the database soon, is the criminal investigation in Macedonia. Actually, this case is not a judgment, but we wanted to keep it in the database because it stands as the only case in North Macedonia with legal consequences related to mountaineering accident. And actually, in this case, there is at least a decision of the public prosecutor. And it's a case with very interesting facts. What is it about? A Macedonian alpine club called Transverzalec called its members for a hike to Mount Ninze between Greece and northern Macedonia. During the climb, the weather conditions didn't allow for a climb, didn't allow for a safe climb. It was freezing and windy, very windy, which is why the organizers eventually decided to turn around. Two experienced climbers voluntarily separated from the group after the group respected the decision to turn around. The two mountaineers attempted to climb the peak despite adverse weather conditions, but slipped, fell down, and eventually froze to death before the rescuers found them. The public prosecutor investigated the criminal liability of the president of the Alpine Club for two criminal acts. The first was called unscrupulous work in the service, and the second, acts against general security. These are two criminal acts which kind of could be identified to the situation such as this. As I told you, it was the first case ever when criminal charges were brought in North Macedonia in relation to some sport activity, climbing activity in the mountains. After a long investigation, the prosecutor concluded that the president did not commit any violation of law or bylaws in organizing and implementing the mountaineering tour. The decision of the prosecutor emphasized that the deaths of the victims resulted from an accident rather than any negligence or misconduct by the guide. This case is significant because it sheds light on the responsibilities of mountain guides and shows that they are safe, also from the criminal perspective, but only if they adhere to good practices throughout a tour. The conclusion of the case, the conclusion of the prosecutor could have been different if the organizers didn't order the group to turn around. And I could continue. I could continue with other cases. LAC is currently analyzing one Spanish case. We are also getting ready for one case from New Zealand and from South Korea, which as soon as we prepare summaries of them, you will find them in the database. But before I conclude, I want to inform you about one Czech case, which I'm currently representing. I'm currently representing families of victims, and in fact, it was a big tragedy because two girls died when going down from Via Ferrata. And what is important to say about this case is that they died 1 year apart. Unfortunately, the guide in this case, who was organizing Via Ferrata tour, didn't learn his lesson, and he continued organizing his tours in the same wrong way, and the accident happened again the following year. The main guide and his colleague have now been accused of double negligent homicide, and the case is going to the court. The case is very important in the Czech Republic because it is not only about the establishing of breaching of duty of care, but it is also about the fact that the legal system in the Czech Republic allowed the guide to continue his practice, even though after the first incident, he was expelled from the Czech Mountain Leader Association. So I'm really looking forward to the next developments in this case, and maybe next time when we see each other, I will be able to tell you more. So, how did you like the menu which I prepared for you? Was it tempting enough for you to become the fans of the database? What is important to add is that the LAC members who are currently searching for new case law and writing summaries of them, they shouldn't stay alone. We would love to get more fans of the database who will be sending us interesting judgments from different countries, or even sending us already the filled templates and the texts of the original judgments. As I said, the website is still a beta version. If you want me to notify you when the project is ready, when we are going really public and famous, just send me an email to klara.dvorakova@holubová.cz. And I will make a note, and then I will subscribe you to the newsletter, because we are planning to send newsletters whenever LAC is going to insert a new case to the database. Also, if you fell in love with climbing cases, do not hesitate to get in touch with British Mountaineering Club and tell them you want to be their representative in the LAC. Just be aware that, as I said, it is a hobby activity. I hope that you enjoyed the pictures during my presentation, because they are all mine. Thank you for listening, and I'm passing the mic to Sam.
Thank you, Klara. And Sam.
Thanks. I hadn't heard that previously. And from a comparative law perspective, to hear about cases brought in different jurisdictions. Now I'm going to talk for the next 20 minutes or so, 15 minutes or so, on winter sports claims brought in England and Wales, typically claims similar to those which Klara was discussing: skiing, snowboarding, mountaineering, tobogganing injuries, ice diving, paraskiing. There are a host of different sports in which people find themselves in the mountains getting injured. So I'm going to talk to you about how those claims are brought and a few of the developments in those areas. And of course, this is an area which has had more press coverage recently in light of the Gwyneth Paltrow trial. Now, don't worry, I'm not going to start putting up videos of plaintiff counsel cross-examining Gwyneth Paltrow, asking about whatever she was wearing, not least because one of the clerks on the way in told me that I don't have an eye for fashion, which I thought was harsh.
I think that's very unfair. It's a great suit.
Thanks, Jared. So the next 20 minutes, 15 minutes or so will be, I'll do a brief word on jurisdiction, duty of care and applicable law. We'll talk about local standards from the standard of care perspective, and then the three kinds of winter sports cases you typically see: collisions, inadequate supervision, and defective equipment. Now, in the interests of brevity, I won't bore you with the pre-Brexit position, and I'm aware that Sarah and Dan are going to be going into some depth, providing an exposition of the jurisdictional side of things later on anyway. They, of course, will talk about Brownlee, Supreme Court's interpretation of damage, which effectively expands the boundaries of the harm required to enable a tortious claim to pass through the jurisdictional gateway. That's interesting, of course, because it effectively broadens the scope for bringing claims through the gateway under Practice Direction 6B 3.19, which requires that damage was sustained or will be sustained within the jurisdiction. And that is, of course, a decision which is going to be beneficial to claimants who've suffered serious injuries during snowboarding, skiing, tobogganing accidents, etc. Claimants will effectively be able to argue that the pain, suffering, and physical injury which they have suffered, first on the skiing slope and then continuing when they get home to their home jurisdiction, will be aligned with the same kind of jurisdictional arguments that Sarah and Dan will take us through later on. And it's worth saying at this stage, for a more thorough kind of jurisdictional run through on a winter sports side, the case of Klara and Slater is worth reading and thinking about. And this is, as I understand it, something that Will Young spoke about at this event last year. So I don't intend to go over that in any great detail. I think the slides are probably online, and he will have done that far better than I ever could. So as far as the duty of care is concerned, of course, you're going to need in a winter sports claim a breach of a rule or provision which creates duties between people. In the UK, typically you have negligence, the Occupiers Liability Act, and nuisance. And of course, there are winter sports claims which are brought in the UK. You could have seen from Klara's presentation, there are mountaineering and various other activities which go on here. But further afield, winter sports claims in France, for example, have specific duties imposed by their code. So Article 1382 deals with excessive speed, and Article 1384 of the French code makes the skier responsible for damage caused by objects under his control, e.g. skis, poles, and it has been interpreted as meaning that there isn't a requirement to prove fault. So effectively a strict liability regime, which will of course make the application of French law a much more appealing prospect for claimants in these kind of cases, which really gives rise to the question, well, which law applies? Allow me a very brief word on applicable law. Pre-Brexit, of course, the UK was bound by the rules of the choice of law set out in Rome 1 and 2. They allow for parties to adopt a choice of law for contractual and non-contractual obligations. Now, post-Brexit, happily, we're in much the same position. The law applicable to contractual obligations and non-contractual obligations, amendment, etc. EU Exit Regulation 2019, that is a catchy title, effectively enshrined the application of Rome 1 and 2 in English law. Now, those regulations do set out some minor exceptions arising from the difference in status of the UK following Brexit. For instance, in the case of non-derogable mandatory rules or certain insurance contracts. But apart from a few specific exceptions, the regulations continue to apply the rules as set out in Rome 1 and Rome 2. And of course, it's worth saying at this point that given the stated desire of the UK government to preserve kind of legal certainty post-Brexit, my view, for what it's worth, is that it's likely that English law is going to continue to mirror those provisions. And in any event, Rome 1, of course, substantially reflects the position which would otherwise apply as a matter of English common law. And so the applicable law in these sorts of cases is going to be determined on the basis of the classic principles, where the damage occurs or is likely to occur, irrespective of the country or countries in which the act giving rise to the damage occurs. And that's Article 4 of Rome 2 for non-contractual matters. And that, of course, is subject to two exceptions. So where the parties have the same habitual residence at the time of the damage, then the law of that country would apply, and where the tort is manifestly more closely connected to a country other than where the damage occurs or where both parties reside. So, having rattled through applicable law, now, of course, regardless of what court has jurisdiction or what duty is to be applied, the court's always going to apply the standard of care in a place where the accident happens. Now, this won't be a surprise to many of you. The best way that I've had it explained to me is to think of drivers driving in identical situations. So in the UK and in Germany, for instance. So in the UK, if I were driving down the M1 at 80 miles an hour, I would be speeding. Whereas if I were to drive down the German Autobahn at 80 miles an hour, of course, I would be driving at the prescribed speed. And that gives you a sense of the standard of care owed to different drivers in different jurisdictions. And the same is true of alpine sports, country to country, and indeed often resort to resort. So claimants will ultimately have to show that the defendant acted in a way which contravened normal practice. And that's obviously going to require, as many of you will know, local standards evidence, often from local ski instructors, and this can be costly, but it's important to get it in early doors when you're dealing with these sorts of cases. I don't want to spend too long on the standard of care and local standards, because I'm sure that most of you will know about them. Only to say that, of course, the case of TUI is important to note when you're dealing with anything local standards related. Well, obviously, the High Court held in TUI that where local standards are unclear, the court won't require claimants to prove standards which are vague, nebulous, or non-existent. But you'll find that local standards are incredibly important in winter sports cases. And winter sports cases typically fall into, as I said on the first slide, 3 different kinds of case. We've got collisions, inadequate supervision, and defective equipment. Now, collisions are evidentially the easiest form of accident to deal with. English courts use the FIS rules, and they work in a similar way to how an English court might use the Highway Code, for instance. Breach of a rule is not negligence, but evidence of negligence. And on screen there, you'll be able to see 3 typically employed FIS rules, which are often used in these kinds of cases. So respect for others, control of speed and movement, and overtaking. And I think it's probably clear how those 3 are likely to interact with a kind of collision case that you'd see in a skiing, snowboarding, tobogganing accident, that sort of thing. Inadequate supervision. Now, these are typically cases brought against ski instructors or holiday companies offering packages. They can be much tougher cases. Effectively, what you're doing is you're alleging that someone was injured and due to inadequate supervision, that they are liable, and that presents evidential difficulties. The case of Goldborn is one which really bears that out. The central allegations in Goldborn were that the ski instructor had failed to adequately assess the claimant's skiing ability and taken her on a slope which was too difficult for her, and then failed to maintain sufficient instruction and or dialogue with her whilst on that run in order to ensure her safety. I'm quoting there from the judgment. And interestingly, the Court of Appeal in that case recognised that the FIS rules do impose a duty on ski instructors to never allow pupils to take risks beyond their capabilities, but the FIS rules didn't mandate how the duty was to be met, and there was no local standards adduced in that case, and to that extent, the claim failed. But that was indeed something which was easily remediable with a good local standards report. So, as I said before, local standards really very important, and also there will often be issues of contributory negligence in these kind of cases. Anderson against Laetier, a very good example of that. The individual skier will often have some negligence on their part, and that's important when you're thinking about early settlement on both sides. So that is, again, something to consider. Again, eye on the clock. The third kind of case that you deal with in these winter sports matters, often defective equipment. Slightly more complex. Now, if you're dealing with defective equipment against potentially a ski shop or somebody who has been servicing your skis within a resort, that sort of thing, then those claims are a lot simpler. But it's important to note if you're dealing with product liability that there are, of course, so bringing a claim against the manufacturer directly, there are slightly more esoteric points to make in terms of the applicable law. And Articles 5(1)(a) to C of Rome 2 effectively provide a kind of cascading list of requirements for applicable law in those sorts of situations. So to start with, you need to be applying the law of the country in which a person sustaining the damage was habitually resident when the damage occurred, assuming that the product was marketed in that country. Secondly, the law of the country in which the product was acquired, again, assuming the product was marketed in that country. And then lastly, applying the law of the country in which damage occurred, again, assuming that the product was marketed in that company. Is a classic case of, if not the first, then the second, if not the second, then the third, and note that each of those cascading rules require the product to have been marketed in that country with the consent of the person to be liable. And there are a couple of exceptions to that, as you'll see on screen there. Article 5.1 provides an exception, and that's an exception which may apply, for example, where the consent of the person said to be liable hadn't been obtained to market the product. And again, there is another kind of saving provision at Article 5.2, which provides a manifestly more closely connected escape clause. So you could argue that a particular law is manifestly more closely connected to the dispute. But again, that's only going to apply in exceptional circumstances, given the use of the word manifestly in the statute. Now, that's 204. I'm quite happy with that. I haven't got anything else that I realistically want to add. So in summary, plenty of scope to bring winter sports accidents claims in the UK, even post-Brexit, and we'll hear more about that from Sarah and Dan later on. If you take one thing away from this talk, is that local standards are often central to winter sports claims, and that defective equipment claims may often throw up difficult choice of law issues. I don't think there is time for questions, but as Will said earlier, if there is anything that you want to desperately ask, then I'm happy to answer those questions in the tea break. That takes me to 2:05 on the dot.
I was about to say that Sam thinks he's talked his way out of any questions, but I'm chairing this. If you've got any pressing questions that can't wait till tea, we can spare a little time.